Hi, my name is Scott Green. I'm the managing partner of the Green Law Group in Simi Valley, California. And today's webinar is a discussion of the difference between an hourly retainer agreement and a contingency fee agreement to resolve payment disputes for contractors. So before we get started, oops, I'm going to change the page here. Oh, here we go. Right. A little technical difficulty. Yeah. All right. I want to thank our sponsors. So we've got Easy Law Construction Notices. Easy Law does preliminary notices for contractors and other professionals throughout the country, and in particular in Southern California. I started Easy Law in 1985 to help contractors take the steps necessary to secure and collect the money they make. So check them out, good service. The Blue Book, probably a lot of you are familiar with. They are great for building relationships and networking. Ventura County Credit Union, they're my lenders, and I put them up here because they've just been fantastic. So if you want a lender that treat you more like an individual as opposed to a member, check them out. Ventura County Contractors Association, we're members, and they're our local contractors association. Wherever you are, I'd recommend you check out your local association. It's a good place to swap ideas, have some fun, network your business. And the Builder's Blue Book, or the Builder's Book, excuse me, they're located in the San Fernando Valley, but they've got a very extensive website with virtually everything that's published or written regarding construction. So if you're looking for a code book or some written reference for construction, check them out. They're an incredibly important resource. All right, so here's just a saying that I believe in. Knowledge is power, and ignorance of the law is no excuse. So we'll talk a little bit more about that. Fair warning, I'm going to give you general information today. It's not specific, obviously, as to any legal concerns that you may have. So if I say something that doesn't seem to fit your situation, don't take it as gospel. You want to talk to a lawyer about your specific facts and how your specific situation matches up with the law, which changes on a regular basis. There are new statutes and new court rulings all the time. So these comments are general and educational in nature and not designed for your specific situation. Okay, a little bit about the Green Law Group. You can read this at your leisure, but basically, our firm is built for contractors. My partner is a licensed general contractor. All of our attorneys here, deal in construction litigation matters and transactional matters. We handle anything relating to construction law from top to bottom. All right, little bios on our attorneys. Okay, fee structures. Well, before we drill down on the differences and pros and cons of an hourly retainer agreement for a law firm and a contingent retainer agreement, let's talk about case evaluations, because that's generally the first thing people want to know is, well, am I going to win? And if I'm going to win, how long is it going to take? And how much is it going to cost? I mean, those are all reasonable questions. Will I win? What will it cost? How long it will take? And an attorney's response to that is, I don't know, I don't know, I don't know. Now, I'm just being a little facetious in terms of, will you win or not? An attorney can't guarantee you an outcome. So even if, I feel really good about your case, I'm not going to tell you, hey, you got a guaranteed winner here. because there's really no such thing. I've been practicing law since 1978, a long time, pretty much exclusively in construction litigation. I have tried and arbitrated hundreds of cases dealing with millions of dollars in claims. And I don't believe I've ever had a case where I didn't continue to learn things about the case all the way through trial. So there's no such thing as, a crystal ball or being able to predict an outcome with any confidence. And lawyers are specifically and ethically prohibited from guaranteeing an outcome to their clients. And you can certainly understand why. If I said, oh yeah, you're going to win, then maybe you don't really pay attention to what it's costing you because I just guaranteed you a win. So I cannot do that. And no ethical attorney can do that. So how long will it take? Well, can't tell you that either, because if we're engaged in a dispute and I'm representing you, there's somebody on the other side and they've got a strategy and they've got, their own position. And I don't know at the outset of a case whether the other side is going to be very aggressive, whether they're going to give up, whether they have real merit to their position, whether they have deep financial pockets and they're going to take this to the Supreme Court. I don't know any of those things. I might have some educated guesses, but that's all they'll be. They'll be guesses. So I don't know if we file a lawsuit, is that suit going to go all the way to trial? If it goes through trial, I don't know if then it will go through appeal. I just don't know. Now, I can make some generalizations. For instance, most cases settle before going to trial, maybe upwards of 90%. Why is that? I think largely because people get financially exhausted. It's expensive to litigate cases. To take a case through a Superior Court trial in Southern California, you could easily spend, $250,000, and that's a shockingly large amount of money. But it could be more. If you're having a jury trials are typically more expensive than trials to a judge. Litigation is also typically more expensive than arbitration, but it's all expensive. And people do get financially exhausted. They also get frustrated, and the time constraints of being involved in litigation are taxing. So, as cases drag on from month to month to month, people's enthusiasm for, fighting for the principle of the matter sometimes starts to, wane just a bit because it's a difficult thing to go through. So, you never want to jump off that slippery slope without having an idea of how far it could go, what it could cost, and understanding that the outcome is always going to be somewhat uncertain. So, all right, having said all of that, what can you do though? How, obviously lawyers do make case evaluations. I do it all of the time. And I can talk to you about the merits of your case and, maybe give you some rough percentages, what I think at any point in time during the course of your case. So let me tell you the things that I'm going to look at. If you contact me and you're a licensed contractor, let's just say you're owed $100,000. Now that's a big chunk of money. And you want that money back, and you want it back sooner rather than later. And you don't want to spend $200,000 to get 100. I understand all of that. But where are we going to start in terms of evaluating and assessing your case? Well, I'm going to start with your license status. In California, contractors must be licensed by the California Contractor State License Board, and they must maintain that license at all times during the course of their performance. So I'm going to look up your license number on the Contractor State License Board's website, and I'm going to determine whether the license is currently active, and then I'm going to look at the history, and I'm going to make sure, I'm going to check to see if the license was active at all times during your performance. And I'm going to order from the Contractor State License Board a certified record of your license history. Because if we're going to go to court to argue for the recovery of disputed contract amount, as a licensed contractor, you have to prove that you were correctly licensed at all times. And if you cannot do that, or if you skip over that step, you're going to lose. And by the way, if it turns out you are not correctly licensed, not only will you not be able to collect any money, but you can be compelled to give back all of the money that you received on a particular project where you were not correctly licensed. So that's obviously a very important step. Now, you might think that it's kind of obvious that you should be licensed, and who would make that mistake and perform work without a license. Well, rough guess is about 5 to 10% of the people I talk to have a problem with their license. Now that problem could stem from having the license suspended because they let their license bond expire. It could result from having employees but not having workers' compensation coverage. It could be that you worked outside the scope of your license. So maybe you have a license for concrete work and you were doing a significant amount of electrical work for which you are not licensed. That's a problem. So it also could be probably one of the most common situations I see is at some point you decided to incorporate your business or even form an LLC, a limited liability company, and you had an individual contractor's license and you incorrectly assumed that your individual license would cover your new corporation. Well, it doesn't. If that's your situation, you've got to get a separate license number for your corporation or your LLC. You can't use your personal license. And if you find yourself in that scenario, you need to chat with an experienced construction lawyer ASAP. So licensing. So we've covered that. The next thing I'm going to look at that I mentioned briefly is, does your license record indicate that you have workers' compensation insurance? Because if it says, for instance, that you filed an exemption claiming that you have no employees, I'm going to take a very careful look at that. Because if you have just one employee and you do not have workers' compensation insurance, then your license can be retroactively suspended back to the point at which you should have but did not have workers' comp. Well, what does that mean if your license is retroactively suspended? Well, it means you were contracting without a license, and not only can you not go to court to compel payment, but you could be compelled to return the money. In addition to other bad things, contracting without a license is a misdemeanor. It's a criminal act violation. So we're going to check workers' comp. We're going to have a conversation about that. Sometimes folks misunderstand who is or who isn't an employee. They might think that they can hire somebody to do, let's say, plumbing work independently and pay them as an independent contractor. But in California, unless that plumber has its own contractor's license, they're automatically going to be considered to be your employee. So when you hire subcontractors, if you are in that position, you want to verify that they have a license and that they properly maintain the license, and that they also, if they have employees, have workers' comp and maintain that coverage throughout the course of your work together. Critically important. Okay, so license, we've checked that. We've checked workers' comp. The next thing we're going to talk about is, well, how much money are you owed? Because, we can't ignore the fact that litigating is expensive. So if you walk in and you say, hey, Scott, I'm owed, 15,000 bucks. Well, that's not chump change, but are you going to file a lawsuit to track down $15,000, knowing that it could cost you significantly more than 15,000 to get your 15,000? That's going to give you some pause. So if the amount you're owed is, let's say, anything less than $50,000, I'm likely going to tell you, listen, let's try some alternative approaches before we file a lawsuit. So, for instance, excuse me, we might, write a settlement demand letter. We might get on the telephone and have a conversation. We might go to mediation. I might suggest that you provide an incentive to settle by offering a discount. We're going to try to work around the possibility that you have to litigate or go to court or go to arbitration for this $50,000 claim just because of the expense. And that's even, by the way, if I'm very, optimistic about your chances of recovery. Because it isn't just the expense, it's also the time. It's the time that it may take to work through the process. Going to trial, for instance, is typically 12 months to 18 months. Going to arbitration, if you have an arbitration provision in your contract, it's typically 3 to 9 months. So if you're going to have to go all the way to a judgment in court or arbitration, you're going to be without the money all that time. And if you're hourly, you're going to be paying an attorney every month, during the performance of their work on the case. So that's something to take into account. So if you can put money in your pocket now, offering a 10 or 15% discount and avoid all of that, well, that makes some business sense. And one of the things that I'm going to do when I evaluate your situation is try to help you make a good business decision regarding the management of your legal dispute. So the amount of money is important. Now, if you walk in and you say, hey, Scott, I'm owed, $1 million. Well, we're going to approach that a little differently, than we would 50,000. But, the amount owed is certainly a significant factor. So after that, what else? What are we going to look at? I'm going to look at your contract. I'm going to ask you to send me a copy of your contract. Now, hopefully, you have a written contract. Because while an oral contract may be enforceable, oral contracts are, highly fertile areas for disputes and to be avoided. So you want to put your agreements in writing. So hopefully you have a written contract, and I'm going to ask you to send that over. And I'm going to be looking at a few key provisions in the contract. I want to know, for instance, whether or not you can recover your attorney's fees in the event of a dispute over payment. Why is that important? Well, remember I said it could cost you $250,000 to go to court all the way through trial or more. Well, if you're owed 100 and you end up spending 150 to go to trial and you win, you're upside down 50,000. So having the ability to recover your attorney's fees is critically important. And by the way, unless you have a provision in your contract that provides for the recovery of attorney's fees in the event of a dispute and awards those fees to the winning or prevailing party, you may not be able to get your attorney's fees. It's not an automatic. There are a couple of statutes that provide for attorney's fee recoveries in the event of a payment dispute, but it's not automatic. So if your contract doesn't contain an attorney fee provision, we have to talk about that, because if you can't recover those fees, every nickel you spend on a lawyer is a net reduction on anything you might recover. So, and I'm going to look to the contract to see if we can recover those fees. I'm also going to look to the contract to see if there is an arbitration provision in the contract, or a mediation provision, or some methodology for resolving disputes that takes the dispute out of the court system, because that's going to affect how much time, how much money, and how to proceed. So I'll look for an arbitration provision, and that'll be a factor. As I mentioned, arbitration's quicker and generally less expensive, so we want to discuss that. Now, the other thing I'm going to look at is, are there potential cross claims against you? So for instance, I'm going to ask you, when you follow up on your unpaid invoice, what kind of justification or excuse or explanation are you being given? So for instance, you make a phone call and you're out 100,000, and your customer says, well, I haven't paid you because I haven't yet been paid. You say, okay, that may be permissible. You may have something called a pay when paid provision in your contract that allows your customer some flexibility in terms of when to pay you. But if you do get that answer, I'm going to tell you to follow up with a confirming email. So for instance, you call and they say, well, listen, your work's fine. We have no problems with you. We've got all the right paperwork. We just haven't been paid by, let's say, the owner. So we don't have the ability to pay you yet. You're going to send an email to confirm that conversation. And you're going to make it specific and say, hey, Bob, Joe, Sue, whoever you talk to, I'm writing to confirm our conversation this morning regarding my unpaid outstanding invoice in the amount of $100,000. And I'm writing to confirm that the only reason you've not been able to pay us at this point is because you have not received payment from the owner. And if this isn't correct, please let me know. And you fire that off. Well, why is that important? Well, let's say, 3 or 4 months down the road, you still haven't been paid, or maybe even sooner than that, you file a lawsuit because it's a big chunk of money. And now you're in this litigation, and all of a sudden there's a new excuse for your non-payment. Now, perhaps there's an assertion that your work was negligently performed, or you delayed the progress of construction, or you included materials that were not per specification, or any number of excuses other than what you were originally told. Well, if that should happen, and by the way, you should anticipate the likelihood of that, because, stories do change over time, sometimes justifiably, sometimes not. But if the story changes and now you're going to court and you're able to present that written evidence of that written communication where you say, hey, look, right at the outset, I specifically asked, is there anything that you need from me? Or is there any reason why I've not been paid? And the only explanation given to me was that payment hadn't come through from the owner. And I wrote and I confirmed that. And in my written confirmation, I asked them to let me know if there was anything else they needed from me or anything else that affected their ability to pay. And I got nothing. And that's going to be very helpful to you at trial. So you want to make that written communication, which brings me to another point in my assessment of your case, is how does your paper trail look? And what do I mean by paper trail? Well, keep in mind that if a dispute goes to court or arbitration, the arbitrator or the judge, they weren't personally involved in the project. So they're going to learn everything about the project through the witnesses and the documents that are presented as evidence in the dispute. Well, the stories from witnesses may vary, but the written documents are not going to change. So lawyers are going to, build their cases largely on the written evidence, the written record, the paper trail. So that email that I referenced earlier, where you wrote to confirm that there was nothing holding up your payment except the fact that the owner had not paid, well, that's a written document that will be part of your paper trail supporting your claim. So I'm going to ask you to send me relevant correspondence, emails, texts, letters, although I hardly ever see a letter anymore. So I can see, well, what were the parties saying to each other during the course of the dispute about the dispute? And, how does that favor one side or the other? Because I know that a judge, arbitrator, jury will be considering these things ultimately in deciding the outcome of the case. So paper trail, very important. And something to know about the paper trail is that when you are writing about your dispute, consider that the ultimate reader of what you write is perhaps a judge or an arbitrator or even a juror. And so how do you want your writing to be perceived? Well, you certainly want to be factually accurate. You want to be polite. You want to be reasonable. Because if somebody reads a very snarky, email or text or, something that is nasty, that might not, reflect well on the writer. And you don't want to lose your case because somebody thought you were kind of a jerk in your written communication. So consider that everything you may write to someone in the course of a dispute may ultimately be read by a person or persons who are deciding the outcome of the case. So keep that in mind. So I'm also going to look at, again, we're talking about assessing your case, whether you have general liability insurance. Why is that important? Well, in a large number of cases, you may sue for your claim. We're talking about a possible claim for 100,000 or more. You might get sued back, and you might be sued back for something that could be covered by your general liability insurance. Now, what might that be? General liability insurance is for the protection of or the defense of claims relating to damage to property other than your work product that happened unintentionally or accidentally. So just for instance, let's say you put a roof on a building, you didn't get paid for the roof leaked, the water damage was extensive, and they're using the cost of repair to offset the amounts owed to you. Well, your general liability insurance may actually provide coverage for that claim for the water damage. So that's kind of an important thing. So I'm looking at all of these lists of things and more to make an assessment of your case. And now, if I'm going to consider taking your case on a contingent fee basis, I want to, as an attorney, I want to consider that, well, perhaps I'm going to do better than I would do on an hourly basis if I take your case on a contingency fee basis. So how does that work out? So back to you, the hypothetical $100,000 claim. Let's say I've looked at your license and your contract and your paper trail and your insurance, and we've talked about, factually what happened. And I think you have a viable defendant, and maybe you have secured your claim for payment with a mechanics lien that's properly supported by preliminary notice, and/or you have a stop payment notice against the lender, so that it looks like if we ultimately prevail, we'll actually be able to recover money. And I look at all of those things and I think, you know what? I think there's a very good likelihood of prevailing in this case. And you asked me to consider a contingency fee agreement. And I think, okay, well, let's say there's enough money involved that I want to take the risk of going forward on a contingent fee basis where I'm going to carry the attorney's fees, maybe that 250 or more that it could cost to take a case all the way to Superior Court for trial. And you're going to pay the hard cost. So, and that's a typical arrangement where you're going to, on a contingent agreement, you're going to pay court costs and filing fees and things like that. Maybe that amounts to still several $1,000s in a case that goes all the way to trial, but not the tens of thousands for attorney's fees. But why would I take it on a contingent fee basis? Well, because I like my odds, and I'm made an assessment, and I think, okay, I'll take the risk of recovering a percentage of the amount owed to you, maybe anywhere from 30 to 50%, depending upon the circumstances. And then I'm also going to be potentially able to recover all of the attorney's fees that I put into the case if we prevail. Now, let's say on that $100,000 claim, we win, we go to court, there's a little offset, but we win 80,000 bucks. Let's say we had a split at the time of trial that was 50-50. So you're going to get 40 grand. But let's say that I spent 200 plus in attorney's fees to go take the case to trial. After winning, we're going to go back to court and we're going to ask the court to award those attorney's fees. Whatever the court awards, if anything, is going to go strictly to the attorneys because you didn't pay attorney's fees. So, I'm going to get that money back. And then we're also going to ask the court to award the cost that you put out. So if we prevail, you get that back. So there's the basic, difference between hourly contingency. On a contingency case, you're going to split the baby with the lawyer. Now, if you think you got a really solid case and you can finance the case on an hourly basis, you're going to do better than you're going to do on a contingent case but you're going to have that monthly outflow to pay the attorney through the course of litigation. So that's the comparison between hourly and contingency. And it all really starts with the strength of your case. So again, my name is Scott Green. I'm the managing partner of the Green Law Group. If you have questions about this presentation or anything in any of my firm's practice areas, shoot me an email, Scott at the Green Law Group, and I'll get back to you as soon as I can. Thank you.